Thank you, Vanessa, for the kind introduction. I think you were referring to a session which I chaired 2 years back, if I remember correctly, when we spoke of the construction of the European company law skyscraper. And I compared that to the Cathedral of Cologne. And I said the Cathedral of Cologne to build took about 600 years. And I said, compared to that, we are just at the beginning of the construction. We have barely reached the basement by now. And then we concluded the session with a remark, now don't be concerned. I tell you now why the Cathedral of Cologne to build took so long. Simply because they stopped work for 500 years for lack of funds. So I don't think I can match that again, Vanessa, but I'll try my best. Dear colleagues, some general remarks first. Cross-border conversion of companies is a subcategory of cross-border mobility of companies. Under primary law, that is Article 54 of the TFEU, companies, just like individuals, enjoy the freedom of establishment across the border, as that is stipulated in Article 49 of the TFEU. That is the relevant article for mobility, dealing with mobility for our purposes. Article 49, in clear language, unequivocal language, says restrictions on the freedom of establishment of nationals of a member state in the territory of another member state shall be prohibited, full stop. Let's leave Article 49 for the moment. More details follow later. Let's now turn to what is a company. Article 54 says companies shall be treated in the same way as natural persons who are nationals of member states. That means companies enjoy the same freedom of establishment. Now, what is a company? The para 2, the second para of Article 54 requires two things. First, a company must have been formed in accordance with the laws of a member state, i.e. not with the law of a state outside the Union. And second, it must have its registered office, central administration or principal place of business within the European Union. So there is a double requirement. That double requirement reflects the difference among member states on when does a member state consider a company to be a company under its own law or under the laws of another state. As you know, there are two major doctrines in this respect. One is the statutory seat doctrine, which says the statutory seat controls the applicable law. It's the connecting factor. And the other one is the management or real seat doctrine, which controls the applicable law as connecting factor. Now, both these doctrines, and that's important to realize, have very deep roots, historic roots, which go back by centuries. I don't want to go into details, but you need to realize the following. States with colonies abroad tended to give as much freedom as possible to their companies so that they could operate abroad, in particular in the colonies. And give the freedom to the companies means to the shareholders and to the management. So the statutory seat in that particular state was sufficient for the recognition of the company in such state, no matter where they would exercise their activities. Take the example of Hong Kong and Shanghai Banking Corporation. They started their operations out there and were not active in the United Kingdom initially. Contrary thereto, states without colonial background had no interest in export of in a comparable way. They were rather interested in controlling the influx of foreign law into their territory and to protect the creditors in their territory. And that's why they invented the management seat doctrine, because the most creditors are likely to be there where the management takes place. So there is a deep-rooted historic background to these two doctrines, which I think you ought to realize as background and to better understand why everything in the field of company law, of mobility of companies across the border, so far has been quite difficult to achieve on the union level. Now, more details, and back to Article 49, the freedom of establishment article. Article 49 prohibits the restrictions on the freedom of establishment of nationals, and as we now know, also of companies of a member state in the territory of another member state. Thus, there are two states involved: the state of origin of the national or of the company, and for the company, that is the state of origin, and the state of destination, or the state of establishment in the foreign country, or the company that, or the state where the company wants to convert into. It's important always to remember there are two states possibly involved and their restrictions on the freedom of establishment. Depending on this distinction, the cases of the ECJ are classified by terms, or at least colloquial speaking, by speaking of country of origin cases or country of destination cases. Both kinds of restrictions in the country of origin and in the country of destination have for a long time been considered to be treated under union law absolutely in parallel. That has for a long time been the belief. That belief turned out to be incorrect when the ECJ handed down its Cartesio judgment. Now, the first case, Daily Mail of 1988. Daily Mail and General Trust plc, which was a holding company, wanted to transfer its seat of management to the Netherlands, where it wanted to sell almost entirely tax-free some major assets which it had on its book. Company law-wise, that intended transfer was no problem. United Kingdom follows the statutory seat doctrine, and so do the Netherlands. However, the intended transfer of the management seat required prior consent, not by any corporate authority in England, but rather by the tax authorities. And the tax authorities said no. Now, Daily Mail counter-argued against that no, that consent requirement exercised by the tax authorities was in violation of Daily Mail's freedom of establishment. The ECJ, in its decision, held to the contrary. It stated that, quote, "It should be borne in mind that, unlike natural persons, companies are creatures of the law, and in the present state of community law, creatures of national law. They exist only by virtue of the varying national legislation which determines their incorporation and functioning." End of quote. The court further down says the treaty, in its definition of a company, and remember what I told you about Article 54, para 2, places on the same footing as connecting factors the registered office, i.e. the statutory seat, central administration and principal place of business, i.e., in simplified terms, the management seat. All of this was and still is correct, what the court there said, but the conclusion by the ECJ, in my mind, is incorrect. Namely, the court fails to recognize that at stake in Daily Mail was not the existence, the corporate existence of Daily Mail as a corporation, nor a corporate law requirement for the transfer of the seat of management. At stake was a tax law requirement which lies outside the question which state's law controls the company law status of a corporate entity. And that company law status is the background to Article 54, Para 2, which does not deal with the tax status and the tax seat of a corporation. A consent requirement under tax law is not a connecting factor for the corporate status of a company. England follows the statutory seat doctrine, as I said, and the seat of management, which is relevant for tax law, is not the connecting factor for company law. Nowhere in Daily Mail is it stated that the transfer of the seat of management without the consent would destroy the corporate status, the corporate existence of Daily Mail. I was told that the consequence of a transfer of the seat of management without consent by the tax authorities under English law in those days would have been that tax would have fallen due on the hidden reserves in the asset on the balance sheet. In other words, no effect on the corporate status, but an immediate tax bill. Now, so far my comments and my analysis of Daily Mail. It's interesting to note that the ECJ, in a later decision, corrected its Daily Mail decision. I'm talking now of the decision of 2011, National Grid Indus, which involved a very similar case. National Grid Indus was a Netherlands company. It moved its seat of management from the Netherlands, like England, also, as I earlier on said, a statutory seat country, to the United Kingdom. The driving reason for that transfer of the seat of management, again, was taxes. National Grid Indus wanted to realize tax-free hidden reserves in certain of its assets in the United Kingdom. The Dutch tax authorities requested National Grid Indus to immediately pay Dutch income taxes on the reserves on its books, regardless of the fact that these assets had not yet been sold. The transfer of the seat of management, i.e. the move of the tax seat to a foreign country, triggered the tax bill. The court held that such request for immediate taxation did violate the fundamental freedom of establishment. It is recognized in case law of the ECJ that tax considerations can constitute a compelling public interest which can justify a restriction. But the court said the request for immediate taxation before the hidden reserves have been realized through a sale is excessive, since it would have been sufficient for the Dutch tax authorities to determine the amount of the hidden reserves at the moment of transfer of the tax seat of management, and to impose taxation only at the point of time when the assets are actually sold. So between the transfer of the tax seat to the foreign country on the one hand and the sale is a time gap. the tax authorities determine the amount of the hidden reserves which eventually are taxable on sale, carry that, so to speak, back in their mind forward until the moment of sale, and when the sale has occurred, then they can present the tax bill. If you apply this rationale of National Grid Indus to Daily Mail, you come to the conclusion that what the UK tax authorities imposed as prior consent requirement was excessive in the terms of European Union law, before the background of the freedom of establishment, because the UK tax authorities, just like in National Grid Indus, could have simply determined the amount of the hidden reserves in the books of Daily Mail, and then sent the tax bill upon the transfer of the tax seat from England to the Netherlands, plus the sale of the assets in question. Now, enough of taxation. Back to company law. In reaction to Daily Mail, the Commission in 1997 tabled a so-called pre-draft for a transfer of company seat directive. The political opposition to that draft forced the Commission to modify that pre-draft in 1998. Political opposition continued. The Commission decided not to pursue the issue of secondary law on the transfer of seat any longer. This does not mean that the issue has come to an end. It rather has become the subject matter of a never-ending story at the political level. The Company Law Action Plan of the European Commission of 2003 announced as measure of the Commission a transfer of seat directive. Well, they got cold feet, so they said we better do a consultation first, which they did in 2006, to no practical result. So the European Parliament stepped in 2009, and in 2012 they resolved on a motion requesting, asking the Commission to present a draft on the transfer of seat doctrine, the transfer of seat directive. The action plan of the Commission of 2012 also promises such a directive. Nothing happened. Again, the Commission said, before we do something, it's better to do a consultation. That's where we stand. In the new proposed mobility directive, the transfer seat is also left out. My guess is no political animal wants to be seen as aiding and abetting tax avoidance, however lawful, by a transfer of seat from one state to another state. You cannot, or it's difficult to explain to the public that the tax revenue, because the assets remain where they are, the tax revenue will move only to a very small extent. The bulk of the taxes will continue to be paid where they have been paid before. But anyway, for the political discussion, no political animal, and commissioners are political animals, will touch this issue. Remember the storm that erupted in the public in France when Depardieu wanted to move his domicile tax seat from France to Belgium. He had to give up that idea, so finally he moved to Russia. Now, so far for the legislative initiatives which have not yet produced a result on the issue of transfer of seat. The next case, the failure by the Commission, i.e. by the lawmaker of secondary law, caused the ECJ to step in with a trias of decisions, Centros, Übersering and Inspire Art. Centros of 1999. a Danish couple established an English limited liability company for the purpose of carrying out its business in Denmark, and only in Denmark, where it had its seat of management. And the couple filed for entry of a branch of that limited in Denmark, into the register in Denmark. The reason was not that the couple wanted to save taxes. The couple wanted to save on minimum share capital. In England, £1. In Denmark, at the time, the equivalent of circa £20,000. The Danish authorities denied the entry of the branch, the Danish branch of the English Limited Liability Company. They could not base their denial on company law, because Denmark follows the statutory seat doctrine just like the United Kingdom does, like England does. So Denmark used another argument, because they had to recognize the company as company. Denmark based their denial of the branch registration on the argument that the couple abused the freedom of establishment by choosing the English legal form for business conducted only in Denmark. The ECJ held, and that's an important holding, held that the exercise of a fundamental freedom does not require a business activity in a given state, nor does it constitute a per se abuse of rights. The court also rejected the Danish creditor protection argument on the ground that the risk for Danish creditors would be even greater if the company were to engage in business also in the United Kingdom, because then there would be not only Danish creditors but also English creditors. So from a creditor protection viewpoint, the Danish authorities should be happy for that company to do business only in Denmark. And further, the ECJ held that the legal form, limited liability company, that term of art, tells the creditors in Denmark that this is not a Danish company with the protection afforded under Danish law, but rather an English company with protection following from English law, which may differ from Danish law. And lastly, the ECJ held that the outright denial of the branch registration was excessive a restriction. The right of creditors to request surety for the difference between English and Danish minimum share capital requirement would have been sufficient, the court held. Speaking in terms of systematics now, Centros has been the first ECJ case dealing with a restriction on the part of the destination country, of the host country, of the move to country. Daily Mail and also National Grid Indus had involved a restriction on the part of the move away from state, the state of origin. So you see the distinction that I spoke about right at the beginning of my presentation is in fact reflected here in cases by the ECJ. The next case by the ECJ is Überseering of 2002. It was also a restriction on the part of the destination state, like Centros. But the destination state had a different regime from Denmark in the case of Centros. And that is decisive now. Deutsche Überseering had brought a Dutch Überseering BV had brought a civil lawsuit before a German court against a German defendant. And that defendant argued that the plaintiff Überseering BV had transferred its seat of management from the Netherlands to Germany, whereby, for purposes of German law, Übersering BV had lost its qualification as a Dutch company and had to be requalified, seat of management doctrine, for purposes of German law, into a German company. And now comes the real problem. For a requalification as a German company, Übersering had not met the proper formalities of formation of a German company. As a result, defendant argued, Übersering, for purposes of German law, did not exist at all as a legal entity, and therefore was not suited, qualified, to stand as plaintiff in a German court. The ECJ rejected this position on the ground that it amounted to an outright negation of Übersering BV's existence as a company. And that negation, the court said, violates the freedom of establishment. Such violation by negation of existence could not be justified by reasons of compelling public interest, such as protection of creditors, of minority shareholders, of employees, of the fisc, etc. The court categorically said in that judgment of Übersering, quote, a necessary precondition for the exercise of the freedom of establishment is the recognition of those companies by any member state in which they want to establish themselves. End of quote. The third case by the ECJ in that trias that I mentioned is Inspire Art of 2003, which was also a move to case, namely from England to the Netherlands, both, as you know, statutory seat doctrines, statutory seat doctrine states. At stake was, like in Centros, an English limited liability company with capital below the minimum share capital required in the Netherlands for Dutch BV and with seat of management in the Netherlands. Dutch law, statutory seat doctrine, as you remember, did in fact recognize the existence of such companies like Inspire Art, but imposed upon such companies certain obligations, namely to call themselves in all their business dealings, including stationery and, quote, formeel buitenlandse vennootschap, formal foreign company. That requirement was held by the court to violate the freedom of establishment because it was not foreseen as a designation in the 11th Company Law Directive, the Establishment Directive. Dutch law also imposed on the directors of the company, for as long as the capital was below the Dutch minimum capital, a personal joint and several liability with the company, as if it were a Dutch company. This was rejected by the ECJ on various grounds, inter alia the argument that the name limited liability company indicates to the public and to business contacts that it is not a Dutch but a foreign company. All the cases discussed so far by the ECJ involved a transfer of the seat of management. I now turn to the cases involving the transfer of statutory seat. The first case was Cartesio of 2008. Cartesio was a limited partnership established under Hungarian law. It wanted to transfer its seat to Italy with a proviso, express proviso, that in spite of the transfer of the seat to Italy, it would remain an Hungarian partnership. The ECJ judgment does not mention whether it was the statutory seat or the seat of management was to that was to be transferred. However, Hungarian law simply requires an Hungarian company to have its seat in Hungary, otherwise it ceases to exist as an Hungarian company. And Hungarian colleagues have told me that that implies both the management seat and the statutory seat. The registered court in Hungary, therefore, refused to enter the transfer of the seat to Italy into the register, thereby preventing Cartesio from setting up the establishment in Italy. The ECJ found therein, to everybody's surprise, no violation of Cartesio's freedom of establishment. The court invoked Daily Mail. Cartesio, the court said, is a creature of Hungarian law. And just like Hungarian law is free to decide under which conditions it recognizes an entity as company under Hungarian law is also free to determine when that recognition ends. In other words, when that company is no longer a company under Hungarian law. In simple words, a company can exercise the freedom of establishment only if it does not lose thereby its existence in the country of origin in which it has been incorporated. Or put it the other way around, the qualification autonomy of the state of origin takes priority over the freedom of establishment under EU law, because the freedom of establishment can be exercised only by someone who exists. Now, having concluded to this effect, the ECJ then made some obiter dicta in numbers 110, 11, and 12 of its decision, which have become very famous because they were completely unnecessary for the decision of the case before the ECJ. The ECJ said in 111, the aforesaid, i.e. the qualification autonomy, does not apply in a, quote, situation where a company governed by the law of one member state moves to another member state with an attendant change as regards the national law applicable, since in the latter situation, the company is converted into a form of company which is governed by the laws of the member state to which it has moved. End of quote. The court goes on in 112, the qualification autonomy of the state of origin, quote, cannot justify the member state of incorporation, i.e. of member state of origin, by requiring the winding up or liquidation of the company in preventing that company from converting itself into a company governed by the law of the other member state to the extent that is permitted by the permitted under that law to do so. Under that law to do so is means the law of the other member state to which the conversion takes place. Such prevention, the court goes on, by the member state of origin, quote, constitutes a restriction on the freedom of establishment of the company concerned, end of quote. In other words, a simple transfer of seat can lead to the end of existence of the company because that's supported by the qualification autonomy of the state of origin. But when the transfer of seat is combined with a conversion into a company law form of another member state, and that other member state recognizes such conversion, then the fundamental freedom of establishment remains applicable. And preventing the company from conversion is an undue restriction of that fundamental freedom. Now remember, Cartesio was a transfer of seat case and no conversion case in the sense of a change of legal form. In Cartesio, the conversion is only an obiter dictum. That's important to remember. The next case after Cartesio was Vale. of 2012. Vale was not a conversion case either. Vale was an Italian SRL company with limited liability by the name Vale Costruzione SRL established. They established was established in Italy, as I said, and they filed in 2006 with the commercial register in Italy the request for deletion from the register on the ground that it wanted to transfer its seat and activity to Hungary. No word of conversion. Vale, Italy, was deleted from the register on February 13, 2006. On November 14 that year, i.e. 9 months later, the managing director of the deregistered Vale, Italy, together with another person, established Vale Epitesi, an Hungarian company with limited liability, and paid in the share capital required by Hungarian law. And in January 2007, the Hungarian Vale requested to be entered into the Hungarian register, together with the indication that Vale Hungary is a successor to Vale Italy. This request was rejected by the register on the ground that under Hungarian law only Hungarian companies can be indicated as predecessor companies. Foreign companies not. While the appeal by Vale Hungary against that rejection was still pending before the Hungarian courts, the CJEU handed down its Cartesio judgment of 2008. And that judgment and the obiter dicta in that judgment on conversion caused Vale Hungary to change its legal argumentation vis-à-vis the Hungarian courts. Vale Hungary now invoked the obiter dicta from Cartesio. It now said that Vale Italy had been converted into Vale Hungary. The Hungarian court jumped on this conversion train, and now the question, how did the ECJ react? The ECJ could simply have argued that Hungarian law was discriminating when allowing the register entry of predecession only for Hungarian predecessors and not for foreign company predecessors. The court, however, wanted to deal with conversion, so they also jumped on the conversion argument. And they held Article 49 and 54 must be interpreted as precluding national legislation which enables companies established under national law to convert, but does not allow, in a general manner, companies governed by the law of another member state to convert to companies governed by national law by incorporating such company. That basically is nothing but a repetition of the main content of the obiter dictum in Cartesio. The court then goes on in Vale and says that Articles 49 and 49 and 54 must be interpreted in the sense that the host member state is entitled to determine the national law applicable to such conversion and thus to apply the provisions of its national law on the conversion of national companies governing the incorporation and functioning of companies. So, however, the principles of equivalence and effectiveness preclude that the host member state from refusing, in relation to cross-border conversions, to record the company which is applied to convert as the predecessor in law, if such a record is made of the predecessor company in the commercial register for domestic conversion. So that's the discrimination argument that I mentioned before. So far, what the court said in Vale. Let me make a comment of a quite different nature on the two cases, on Cartesio and Vale. Both, in my mind, have been artificial cases that aimed at attacking and questioning the Hungarian law that was felt to be discriminative of foreign companies. It was one and the same lawyer who was acting in both cases, in Hungary and in Italy. And the lawyers involved, a German lawyer and an Hungarian lawyer, together with the judge active in the case in Hungary, these cases in Hungary, after Vale had been handed down by the court, toured the country, toured Europe, and made seminar presentations on these two cases. Over and above, I've inspected the annual accounts, or tried to inspect the annual accounts of the companies in question. Vale was a dormant company with the assets amounting only to a few euros. Cartesio was a company only with a few hundred euros and not more. So it is factually not really a conversion case in either case. And it all was made up in order to get the conversion train really rolling. Now, back to the cases. Polbud of 2017. On September 30, 2011, Polbud, Poland, resolved to transfer its statutory seat to Luxembourg and requested to enter into the register that resolution of transfer of seat and the commencement of liquidation. On May 28, 2013, i.e. quite a number of months later, over a year, 1.5 years, the shareholders of Conseil Geotechnik SARL of Luxembourg, i.e. Luxembourg Limited Liability Company, resolved to implement the aforesaid Polbud Poland resolution to the effect to transfer the statutory seat of Polbud Poland to Luxembourg, effective the resolution date of May 28, 2013, in order to submit the Polish company to Luxembourg law, first time conversion element, while maintaining its legal personality. That was the intention. Also resolved on May 28, 2013 was a change of name to Polbud, from Polbud Poland to Conseil Geotechnik of Luxembourg. Now, the question that has come to my mind when reading the facts of that case is that in reality not a merger case across the border, because it was the conversion of Polbud Poland into an existing Luxembourg company. That's the typical setup for a merger, not for a conversion, I would think. But anyway, a few days later, on June 24, 2013, Polbud Poland requested to be deleted in the Polish register on the ground that the statutory seat had been transferred to Luxembourg. In the request to that effect was mentioned the conversion into a Luxembourg company, and the name change to Conseil Geotechnik, however, was not mentioned. The request for deletion of Polbud from the Polish register was denied, and that eventually triggered the reference to the ECJ. Now, you may have wondered, why did it take so long between the Polish resolution in 2011 and the Luxembourg resolution in 2013? The parties involved apparently waited for the outcome of the Vale case. And after Vale had been handed down by the ECJ in 2012, they went on with the transaction and argued conversion. This enabled the ECJ to deal a second time with the issue of conversion across the border. And the court said in the judgment, I quote, "The freedom of establishment is applicable, quote, is applicable to the transfer of the registered office of a company of one member state to the territory of another member state for the purposes of its conversion in accordance with the conditions imposed by the legislation of the other member state into a company incorporated under the law of that latter member state, when there is no change in the location of the real head office of that company." Except for that phrase, when there is no change in the location of the real head office of that company, Everything is well known from the obiter dictum in Cartesio and from Vale. New is that the fact that there is no change in the location of the real head office of that company, i.e. the management seat, is irrelevant for the conversion across the border. The court further held that the freedom of establishment precludes the state of origin from subjecting the transfer of the registered office for purposes of conversion to the liquidation of the transferring or converting company in the state of origin. So far, the ECJ case law. What does that case law now mean in terms of systematics and dogmatics for the issue of conversion? As regards terminology, I would like to ask you to have a look at German law. German law does not use the term conversion. German law uses the term change of legal form. Conversion under German law is the all-encompassing term which includes also mergers across the border or divisions. Change of legal form is what German law says to what we here at union law level label as conversion. The change of legal form under German law does not affect the company's identity under law. Assets, liabilities, contracts, etc. remain with that entity without any change. There is no transfer by operation of law, ipso jure, nor a transfer by contract. When the ECJ in Cartesio, in the obiter dictum in Cartesio, spoke of the company that, quote, moves to another state, the company moves to another state, many German scholars, and probably also scholars outside Germany, interpreted that language by the ECJ that it would mean only a change of the legal form, but that the identity of the company remains unchanged. The company moves from one legal form to another legal form. It's like me wearing in winter a winter coat and in the summer a summer coat. That was the interpretation that was given by many to the obiter dictum in Cartesio. Later, in Vale and Polbud, the ECJ changed its terminology. It said that there is the incorporation of a new company, and under the law, a new company in the host state and under the laws of the host state. This incorporation, I add, is accompanied by the deletion of the company that does the conversion from the register in the state of origin. So we have two elements. We have an incorporation of a new company in the country of destination, in the host country, and we have the deletion, the end of existence of a company in the state of origin. Two different forms. Now, can one combine before the background of the question of identity, unchanged identity, these two elements to the effect to say that although there are two different legal forms from country to country, there is still and nevertheless an unchanged identity. We have to bear in mind that at stake here we are talking about the national competency of member states and how they interpret and understand a conversion or change of legal form. We are not talking at EU level. I'm quite skeptical that in the sense of, at the level of national law, by a transfer from one member state to another, one can say that there's an unchanged identity. Now, the ECJ, as I said, in Vale and Polbud spoke of incorporation. That means that the capital of the company newly incorporated must be duly paid up in cash or in kind. And now we come to the question, what happens with the assets, liabilities, contracts, and of the company that is to be converted? If there is no principle of identity across the border, now how would the assets, liabilities, and contracts move from one company to the other company? By operation of law, ipso jure, as it is spelled out in Article 37 of the SE statute for the conversion of a national stock corporation into an SE, or by agreement. The member state with the newly incorporated company wants to be sure that the capital is actually be paid up. So what will they insist on? They will insist on a transfer of the assets in question by agreement. They don't want to be up in the air on the issue whether the state of origin recognizes the automatic transfer of assets, liabilities to the new company. Now that is clearly an issue that has to be dealt with in the proposal of the Mobility Directive as far as it concerns the issue of conversion. I have difficulties with the present language of the draft. Article 86S says a cross-border conversion shall have the following consequences. All right, all the assets, liabilities, contracts, credits, rights and obligations of the company carrying out the conversion, quote, shall be transferred to and shall continue with the converted company. Now, does that mean transfer by operation of law or transfer by agreement? That, I think, for legal practitioners is a very important issue. Another issue that has not been dealt with in the ECJ case law so far, Cartesio, Vale and Polbud, is the question of procedural steps for conversion that are necessary, that are to be followed in the country of origin on the one hand, the country of destination in the other hand, and how to interface these procedural steps in the two countries. As we know, these steps and the sequence and the interface between them in the national and cross-border merger directives and in the national division directives. Also not covered, except in very, very general words, are issues such as minority shareholders, creditors, employees, etc. The ECJ in this respect makes only some very general remarks. It is clear, however, on the other hand, from the ECJ cases and the remarks made in several cases, that a business law activity cannot be made a requirement for a cross-border conversion. The change of legal form can take place without a change of the management seat, and the use of the exercise of the freedom of establishment is not per se to be considered an abuse of right. An abuse, in the sense of an artificial structure, can only be based on other factual circumstances. Normally that is an issue for the national member states to deal with, but I would imagine that that could also be dealt with in the directive on conversion in order to harmonize, at least to a certain extent, what is felt to be an abuse or an artificial structure. Now, pending secondary law in effect on conversions, lawyers, of course, feel challenged. And they try to do conversions across the border in the absence of secondary law and in spite of the many gaps in the case law by the ECJ. And I want to tell you 3 cases which have occurred in Germany, conversion across the border. One was, 2 cases involved a company, a Luxembourg limited liability company, MSRL. In 2011, they wanted to convert into an MGmbH under German law, from Luxembourg conversion into Germany. And that MGmbH was to be formed as a new company in connection with the conversion. The measures for the implementation of that conversion were based solely on the Cartesio obiter dicta. And that attempt was unsuccessful. The Court of Appeals Nuremberg in 2012 felt the Cartesio obiter dicta were not sufficient to overcome the fact that German national law permitted only German companies to convert. Then came Vale in July 2012. And MSRL Luxembourg tried again. And this time MSRL Luxembourg was successful. The old resolution of 2011 was confirmed and repeated, and now based on Vale, the Court of Appeals Nuremberg in 2013 accepted the cross-border conversion from MSRL Luxembourg into MGmbH Germany. The third case is a case by the Court of Appeals Frankfurt, and that's my final remark, of 2017. The court in that case dealt with a conversion from a German GmbH into an Italian SRL, Italian limited liability company. And based on Cartesio and Vale, the Court of Appeals Frankfurt accepted that conversion across the border. So German law already now permits cross-border conversions inbound, the 2 cases from Luxembourg, and outbound, the case from Frankfurt. In spite of the many gaps in the case law and in spite of the absence of secondary law on it. PS postscriptum, or postdictum rather. In the Brexit situation, lawyers have been looking into the question whether the many limited liability companies with statutory seat in England and management seat in Germany or Austria, also management seat country, could be converted into a German or Austrian GmbH in parallel to the decisions that I've just given you about Germany and based on Cartesio and Vale. Germany and Austria would say fine, but we've been told that by many colleagues in the United Kingdom that the Company House in England and Wales would not accept such a conversion for as long as there is no secondary law in effect. Now, the companies with limited liability and likewise the limited liability partnerships under English law with seat of management on the continent, they are now confronted with the question, what comes first? The entry into force of the mobility directive or the entry into force of the Brexit. And with that remark, I would like to conclude, and I thank you for your attention.